And I have to tell you that Angelika Nussberger was not able to come, and therefore, instead of Angelika Nussberger, Axel Kämmerer will present her paper, but just a short version as far as I know, yeah? Just a 10-minute version, is that right? Please, Axel.
Ja. Vielen Dank. Ja, ich habe die Ehre, Frau Nussberger hier zu vertreten.
I will deliver a summary of Ms. Nussberger's presentation, a presentation about the case law of the ECHR regarding state responsibility on migration issues. Neither in the European Convention for Human Rights or in correlated documentation, the right to an asylum is mentioned. So in all the decisions of the ECHR concerning the right to stay, we will find the following formulation. After a long case law of the court, the signatory states, according to the contractual obligations, they have the right to accept or expel aliens from their territory. We have several articles from the European Convention for Human Rights, Article 2 and Article 3. The Convention is violated if we expel a person to another state where his life or physical integrity are endangered. We need to think about what this person might be affected by once he goes to that country. We have a sentence from the case Soringen against Great Britain. It wasn't about the expulsion of a person, but the extradition of a young German accused of double murder. He was accused of having murdered his girlfriend's parents. He sought refuge in the UK because in the United States he would have been sentenced to the death penalty. The court decided that his rights might have been violated. He didn't receive an inhumane treatment, but the ECHR stated that he had to suffer because he featured on the list of people sentenced to the death penalty. That was the cause of his suffering. Ms. Nussberger speaks about the convention's scope, and she speaks about different categories. The first one refers to the risk of not having enough protection, a threat to the life, and the risk of insufficient legal protection. Ms. Nussberger also deals with current issues in the case law and tries to address open questions. One of the critical issues has to do with the idea that refugees might be transferred to a third state. Relating to the Dublin system, the state that first deals with a case has the competence to cover the whole procedure. But there may exist a possibility of a refoulement. In the case of Greece, in several cases, ECHR ECHR decided on the possibility of a refoulement. This is a criticism to the Dublin system. The second court case, Tarachel against Switzerland, referred to the repatriation of an Afghan family with 6 children from Switzerland to Italy. The ECHR deemed that the convention was breached because the Swiss authorities hadn't made sure, communicating with Italian authorities, they hadn't made sure that that family was going to receive decent conditions in Italy. The court underlined the special situation of a numerous family with small children. The ECHR stated that this is not usually applied in Italy in the case of bachelors. This sentence was not applied in Hungary's case. I won't go into further details. Secondly, we have the obligation to support refugees throughout the procedure. We have the case MSS versus Greece, and the Court of Justice states that countries do not have an official obligation to support refugees in order to provide a specific living standard. Special life circumstances of an Afghan translator are described as dramatic. The state doesn't provide any support whatsoever, and the court views it as an inhumane treatment. Ms. Nussberger also speaks about detention and how just detention is. As for the conventions between the EU and Turkey, the criticism focuses on collective expulsions. The court ruled against Belgium for expelling a group of gypsies, breaching the 4th additional protocol. There are also final identical decisions that do not refer to previous individual decisions, but to police activities against a group of people. The breach of collective expulsion was very clear due to the checks carried out, which showed that the identifications were superficial and didn't take into account the individual specific conditions. As for the inclusion of terrorists into the protection status, we speak about the migration crisis, but there's also a second crisis in Europe. There are cases before the ECHR that refer to the expulsion of refugees that are suspected of terrorist activities at the same time. No exceptions are allowed, and protection has to be granted to everyone. And now I will go directly to the conclusions laid down by Ms. Nürberger. Establishing protection for the refugees' rights makes us hope that Europe will keep having a human face. Even minimum standards might be endangered in the future, and we should consider that. The ECHR has made some progress, although it was difficult to achieve. Based on the absolute character of Article 3 from the Convention of Human Rights, in migration cases, the difficulties that states have to cope with are acknowledged, but there's a clear thread going through all the cases. The court stated that countries at the external borders of the EU are faced with significant difficulties because of the intense flow of refugees and asylum seekers. But given Article 3 and the rights that need to be protected, Europe has to observe the rights of these people. Navid Kermani says that Europe should think back on the useful methods used to resolve crises. We always need to keep in mind that we are not actually dealing with mere figures, but with human destinies.
I would like to thank the organizers for the choice of such important topics. It is very high on the map. I would also like to thank them for allowing me to deliver this presentation. The topic is the regime of migrants in the European Union and within the frame of the European and social dialogue. The European Charter was ratified by 39 of the 42 countries members of the Council of Europe. The importance of the Charter with respect to the protection of the migrants' rights will diminish in time because of two factors. The first of all, 39 countries that ratified the Charter, 28 of them are already members of the European Union, and that means detailed rules on migrants. However, the Social Committee, which is the main body to check the application of the Charter, is not prevented from checking whether the rules in the Charter are complied with, except the rules in the EU, when these rules are more favorable to the migrants. The second reason of diminishing the importance of the Charter is the annex to the reviewed Charter, providing that regulations do not apply only in relationship with the migrants coming from countries that have already ratified the Charter. This limitation is mitigated, of course, partially. by the fact that this charter applies to refugees, while the Social Committee is making efforts to enlarge the implementation of the charter to illegal migrants, so far unsuccessfully. One of the points that must be mentioned is the relationship between the European Social Charter and the other European texts, such as the European Convention on the Human Rights or the legislation of the EU, and their interaction. In the first case, the case of the Convention, the implementation is consistent, meaning that the two documents work together in order to protect human rights, and the Convention is favored most. We also find interaction between the Charter and the legislation of the EU law. Though the two texts are rooted in different logic. The Charter is based on the protection of human rights, whereas European law stems from the protection of the internal market. However, there is interaction between the two, and the EU law has the primacy. The review of the Charter in 1996 was also spurred by the need to create some consistency between the Charter and the EU law. That entailed changes of substance. On the one hand, we may ask to what extent can we apply the Charter to illegal migrants, and on the other hand, what happens in the case of family reunification for migrants. The Charter and illegal migrants. This issue is provided for in the annex to the Charter. And there we understand that the annex just refers to third country, to other signatory countries that are in a condition of legal stay, or they work on the territory, or legal work on the territory of the interested country. This stems from a different interpretation of the text, based on the intention of the parties, given the general intention of the parties the moment when they signed the Charter, namely to assure mutual benefits in favor of their own nationals. This is something which is called internal solidarity. This interpretation, these two types of interpretation, are not the only one according to international law. Though the Vienna Convention from 1969 does not mention the teleological or interpretation of this text, it still finds an important place in the interpretation given by courts, especially in Europe, and especially in the decisions of the European Court of Human Rights, which keenly support this type of teleological interpretation. This interpretation sometimes confirms the textual interpretation, but this does not prevent us from moving further. This teleological interpretation is given by the Committee of the Charter, which is mandated to interpret the Charter. Though there are few cases when we can find at least similar provisions in the two texts, the European Convention and the Social European Charter. There is no division line, clear division line, and that facilitates their interaction. And it influences especially the European Convention of Human Rights and the case law compared to the case law of the Charter Committee. This interaction is characterized by the fact that the Intergovernmental Committee of the Charter invited the Social Committee not to hesitate in their interpretation of some provisions of the Charter. The committee took advantage of the text in the annex in the reviewed charter that provides that parties can expand the application of the charter to people other than those that make the object of the annex, in order to conclude that actually it is about migrant third nationals that come from countries that have not signed or ratified the Charter. The committee that was aware of this, the fact that such a position will have serious consequences on the relationships with the countries where from these illegal migrants come from, correlated their interpretation with the fact that the obligation of the state parties will not fall within the scope of its supervision. The application of several provisions in the Charter could, in specific situation, ask for equal treatment. What does it mean, specific situation? The committee has not explained actually something like that through an interpretative statement or in any other way. It was informally interpreted by its former president, Matti Mikola, the former president. In the sphere of human rights, it is hard to understand why third country nationals would not be entitled, faced with a threat, or why children coming from third countries would serve as labor hands, cheap labor hands, or become victims of sexual exploitation or inhuman treatment without any protection and sanction. We can say the same about migrant adult workers that are subject to forced labor and people that work in unhealthy or dangerous conditions and are subject to sometimes sexual harassment or cheap labor hands, which violates the imperative standards that are set out in the texts regarding labor. These rights are not considered by the Social Committee that adopts a restrictive position. We must admit, however, that progress has been made by the committee in some of the fields of social law, such as dwellings or the health of illegal migrants. The committee has examined the problem of adequate dwellings for illegal migrants and considered that the signatory parties are obliged to implement this right. In the same time, it added some restriction, namely, illegal migrants are not entitled to the same level of conditions as the general population. With regard to healthcare, The committee took a positive position with some restrictions, such as the right to health care of unaccompanied minors, putting together the provisions of Article 17 of the Charter and Article E of the Review Charter, which do not allow for the need to a legal residence. The committee considered, on the other hand, that the right to health care does not apply to the parents of the illegal migrants. Except the situation when they need emergency care. This restrictive approach in the scope of the protection of the social rights caused the negative reaction of the former president, because the principle of dignity is a universal obligation, which means that this principle must include the right to dignity, for instance, income, temporary dwelling, emergency health care, or emergency social welfare. There is a system of interdependencies in place, which makes it difficult to avoid the possibility to interpret the Charter or to apply the case law or related to illegal migrants. These positive measures in the field of healthcare, for instance, are the duty of the state, even if the signatory states signed this document in trying to avoid the related cost. But nothing prevents an extended interpretation in order to better protect these migrants if the economic situation of a country allows it. But if we consider the economic crisis in Europe, which started in 2008 and seems not to have ended yet, such better protection seems an illusion. That is why the committee chose to stay a bit on the side on this in this field. Family reunification is the most important thing within the protection of the migrants' rights, because family reunion has developed a lot in the last few decades. The members of the family represent an important share in the total number of migrants. This is something which is acknowledged inside the EU, which adopted a directive on family reunification. Reunification is also part of the Charter, Article 19, paragraph 6. But there it is only mentioned the right of the migrants to family reunification without any further explanations. The annex defines the family of the migrant worker as the wife and unmarried children that are considered by the reception state as dependent. This rule is linked to the idea of family. We sometimes are in agreement and sometimes in disagreement with the Convention on Human Rights. What does it mean, the wife? A wife goes hand in hand with spouse. Wife refers to a wife according to the law. But nobody mentioned about the civil union of people or gay couples. This is something which is placed at the discretion of the reception state. which creates an opposition with the case law of the ECHR, who, based on Article 10, stated that the relationship of a gay couple that are in a de facto stable relationship will fall in the scope of family life. With regard to something that is linked to children and the relationship between parents and children, the Charter from 1961 used to provide that the reviewed Charter changed some of the provisions. In 1961, the Charter could not be complied with because a child was a child of the migrants only if they were under 21 years of age. States considered that the committee did not make a deep analysis of the situation. In Article 8 in the Convention, the Strasbourg Court dealt with these matters, such as the existence between parents and children, even when a child does not live with either of the parents, or about what happens when a child stays in one of the signatory countries and another child in another state. Another aspect that drew the attention of the committee are the restrictions in the social charter in the exercise of the right of family reunification. They stem in Article G of the reviewed social charter. All these restrictions are proportional and necessary in a democracy. The committee controls the moment when it examines the report of the member states that have ratified the text. They verify whether the domestic law provides for measures, for unjustified measures, which are forbidden by Article E in the reviewed charter. The committee considered that the demand present in several of the domestic legislation that migrants should have enough income to cover for the cost of maintaining their families without taking into account social welfare is excessive. And when we calculate the income, sufficient income, we must not remove social welfare from support. That this position is in disagreement with the case law of the Strasbourg Court, which excludes such benefits. On the other hand, the committee examines if this enough or sufficient level of income is not something excessively calculated, too high, adding obstacles in the way of family reunification. Another restriction regards healthcare, including drug abuse and mental disorders. The committee constantly noticed that the signatory states cannot refuse entry on their territory with the purpose of family reunification on reasons such as poor state of health. Another restriction asks for the migrant to have an adequate dwelling. The committee considers that such a restriction should not be so severe, so adverse to these migrants, and that family reunion shouldn't be blocked by such requirements. The committee said that the state parties should not apply such requirements in a blanket manner. The committee also analyzed some restrictions about the duration of the legal stay applied by some countries. The duration before family reunification. The committee also considered the restrictions imposed by several states to the family members to pass an integration text or a language test before or after they enter on the territory of the reception country. The committee considers that all these restrictions come in violation of Article 19, paragraph 6 of the Social Charter because they rather prevent than facilitate family reunion. Last but not least, one last restriction on family reunion is something that we find in the legislation of some signatory states, which refers to the expulsion of members of a migrant family. And this is something provided in Article 19, paragraph 6 in the Charter, as well as in the past, the same thing was in Article 16, paragraph 8 on the return or expulsion of the migrant. The committee concluded that the members of a migrant family should not be expelled in case the migrant himself is expelled. Thank you.
Redimas. Our next and our last speaker is Judge Popescu from the General Court of the European Union, and he will give us he will deliver the integration of migrants from the perspective of the ILO. Please, the floor is yours.
Mulțumesc, domnule președinte.
Thank you, Chair. Although I'm the last one in speaking, I would like to congratulate the organizers. I am here because of two ladies, Ms. Tănăsescu and Ms. Julia Iliopoulos, who managed to convince me by telling me that I should speak in the honor of a great name, Deputy General Manager of the IOM, the ILO. I will speak about the situation of migrant workers in a legal situation. In a regulated situation. Ms. Stella Haxwith, I hope I've pronounced the name correctly. I apologize if I haven't. The lady has introduced some figures showing that the ILO is concerned about these phenomena. My intervention will focus not so much on the ILO figures, but on its regulations. I will stick to the text without making additional comments. The ILO is a very old organization, the only one which managed to survive the Second World War. Ever since its foundation, almost 1 century ago, in 1919, the ILO granted particular attention to migrant workers following World War I, when big groups of people began to move from one side of Europe to the other. The preamble of the ILO Constitution mentions as an objective, among others, the defense of the interests of people working abroad. This initial interest shown for the situation of migrant workers is reflected also by the fact that the first two recommendations adopted in the first session of the ILO conference in 1919 encompass provisions relative to the international cooperation in order to ensure equal treatment provided to migrant workers. Recommendation number 1 per 1919 on unemployment, and recommendation number 2 per 1919 on mutual treatment. The two recommendations are mandatory for the state, but they don't have the same value as the convention. Over the course of the following 20 years, the ILO kept on including in its conventions and recommendations some provisions regarding migrant workers. In 1939, the first convention on the theme was adopted. It was Convention 66 per 1939. Against the unfortunate historic backdrop, it was never ratified and didn't enter into force. The repeal procedure didn't exist up until recently. In 1949, following the World War II, the ILO and UNO signed an agreement separating the competencies of the two organizations with respect to migrants. The same year, Convention 97 per 1949, revised version, it revised the one in 1939, as well as recommendation number 86 per 1949 concerning migrant workers were adopted. Until 1974, other ILO instruments were adopted. Although they were not directly related to migrant workers, these tools included clauses referring to migrant workers, such as Convention number 117 per 1962 on social policies and Convention 188 per 1962 on equal treatment. Although the ILO conference resolutions stressed the need to design adequate instruments related to migrants, it was in 1975 when Convention 143 per 1975 on migrant workers and Recommendation 155 per 1975 on migrant workers were adopted with a view to covering problems that hadn't been regulated or those issues poorly covered by Convention number 97 per 1949 or Recommendation 86 per 1949. The four instruments were subjected to a full-fledged scrutiny during the ILO conference in 2016, following a decision made by the Management Board in June 2014. In order to assess the impact of these international instruments on the labor market, it's normal to ask ourselves where the ratification of the two conventions stands. Out of the 186 member states of the ILO, 49 states ratified Convention 97 per 1949. Only 23 states ratified Convention 143 per 1975. Only 17 states ratified both conventions, which are complementary. Convention 97 per 1949 included numerous flexibility clauses that allowed less developed states to adopt the convention. The convention in 1949 included, as I was saying, flexibility clauses. Out of the 49 states that ratified it, 18 states expressly disregarded the provisions of the 3 appendixes, which are more demanding and provide more solid protection to migrant workers than the convention. 5 states excluded the provisions of Appendix 3 and 2 the ones in Appendix 2. Let's see the correlation between these instruments. Convention 66 per 1939 was ratified by no state whatsoever. It was deemed as unacceptable. In 1949, the ILO conference that adopted Convention 97 had to identify those legal solutions that would preclude the failure of the 1939 Convention, but also to protect labor migrations, which were massive after the Second World War, granting the broadest possible protection to migrant workers. 25 years later, in 1975, the Convention 145 was designed. The problem of migrants had become an important one with very serious implications. The rationale of the 2 new instruments was for them to become complementary to and interdependent with the two ones drafted in 1949. Convention 97 regulated the conditions for organized migrations, prohibiting discriminating treatment between migrant workers that are legally in a country and domestic workers in 4 big fields: labor and life conditions, social security, taxes related to work activity, and access to justice. Part 1 of the convention in 1975 expresses the will of the international community to regulate the problems generated by uncontrolled migration and the illegal use of migrants. Convention 143 states once again and complements the equality and non-discrimination principles. The conventions from 1949 and 1975 impose obligations to all countries, countries of origin, transit, and destination countries. I will skip some paragraphs. The convention in 1949 is the first instrument where we can find a clause referring to measures against deceitful propaganda regarding immigration. It's a flexibility clause. Basically, Convention 97 guarantees migrant workers no less favorable treatment compared to the treatment granted to domestic workers. It ensures the observance of fundamental human rights for all migrant workers, including those ones with an illegal status in a different country, and to ensure equal treatment and chances of migrant workers in a legal situation as compared to the national or the domestic workers. The analysis of the four instruments in 2016 during the ILO conference makes me draw the following conclusion. The conventions are compatible with demands that exist in today's world. The migrations in the past years couldn't have been anticipated in 1975. And one last issue. If these are the regulations of the ILO, we should ask ourselves, what is the number of migrating works that these regulations might be applied to? I'm referring strictly to migrant workers. According to ILO estimates, there are 150 million migrant workers, out of which 57% were men and 43% were women. Almost half of the migrants, 48% of them, are concentrated in North America and in the northern, southern, and western Europe. The migrant crisis was viewed as the most severe crisis after the Second World War by the ILO, although it was viewed as a humanitarian crisis. And over the past 3 years, the ILO has thought about the possibility to provide jobs to the refugees. This year, for the first time, President of the European Union, Mr. Jean-Claude Juncker, went to the European Parliament and delivered a speech stating that the European Union had to face brutal reality, and he highlighted the need for cooperation between states, trade unions, and employers' associations. And something which is not related to my work as a judge. The migrants crisis and the European agendas. The European agenda on the migrant crisis is somehow ambiguous and doesn't have a long-term vision. The asylum policy, as well as the acquis, which seem to be fully enshrined, will need to be revised.
Thank you very much, Judge Popescu. Now, there is a possibility to pose question to all speakers of the afternoon. So, are there remarks, objections, additions? Any other questions? Jacques.
Je voudrais, en tant que
As I'm a member of the executive committee charged with the agenda, I would like to do a mea culpa. We didn't invite a specialist in international public law to tell us about the international migrant law, because such a field does not exist. We did not invite someone from the European Union Service of Migration to know whether they try to study this topic, because this group of action is charged with many things that you are charged with yourselves. Now, we are asking the question. Maybe among you there are people that have worked with the External Action Service, and if so, what do those people do?
Merci.
I had something to do with the External Affairs Office with the Swiss Agency for Development. In the declaration from Paris regarding the development aid for developing countries should include precise objectives in the implementation of migratory policies. And I cannot believe, it's hard to believe that the help for development given to the governments of these developing countries, sometimes very corrupt types of governments, that they do take the support, but they do not put in place concrete policies. So I believe that the External Action Service has a lot of funds available and that it should exert more pressure on various channels. I can't say now whether this pressure would bring good results or not.
The case, I would say thank you very much to all speakers of the afternoon, and thank you very much to all participants of the session in the afternoon. And we meet each other in the evening, I think, or tomorrow morning. Yeah, tomorrow morning. Okay. Good evening.